Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm here today with Miki Matrician, who is co-managing partner of our Boston office, where we are today. Good to see you again, Miki.
Hi, Kim.
All right, so today for our installment, we're going to talk about the third part of our three-part series on mergers and acquisitions. This one is about the permanent resident process.
Thanks. So, recently we had a client who was acquired by a larger entity, and we went through this exercise. So, we thought it would be helpful to break it down in terms of the impact of a merger or acquisition on green card cases for clients.
Yeah, so when HR and global mobility professionals find out that there's a merger and acquisition, as we mentioned before, always consult counsel, talk about what is happening because every situation is different and unique. And HR professionals really do need to be involved in this from the beginning. It's really important in order to be able to keep key personnel as well as, any really good employee. You want to make sure that you understand what the employee population is. So the first step is to break down the foreign employee population at the company, put together information about who are they, what is their status, when is their expiration date, and what we're talking about today, where are they in the world of permanent resident process?
Yeah, absolutely. Because it's not just a non-immigrant immediate, visa situation that you have to deal with, but it's really also the downstream effect for a green card case, which is often the goal for many foreign national employees. So the way to break it down really is based on PERM, I-140, immigrant visa petition, and I-485 adjustment of status. I guess just to set the stage, when the acquiring company is a successor in interest, and what does that mean? It means that that acquiring company takes the rights and the duties and liabilities of the predecessor entity. And so that's initially what Immigration Counsel is looking at. For example, in the situation of my client who got acquired, that's the initial step in terms of analysis. And then, we map out all of the employees and where exactly they are in the permanent residence process, starting with, as I mentioned, the PERM, and where within the PERM process are they. And then I-140, if the acquisition happened when the I-140 is being prepared or after they filed, what happened? So we'll walk through that briefly. So in terms of the PERM, to avoid impact, I guess, the job opportunity has to be the same and at the same location if someone's PERM is underway. And so, in this situation for my client, there were a number of PERM recruitments that were underway. And so the PERM recruitment had to be done in the new company's name. And then there were some where the recruitment was already done. We were ready to file the PERM application. And so the company's official legal name that's in effect at the time of filing the application is the name under which companies have to file the PERM with the Department of Labor. So that's PERM. One additional note is that, the employer might have to justify or to prove the relationship between the entities, this acquisition documentation in an audit if the DOL comes back and asks for that. In terms of the I-140, for those individuals where the PERM was certified and the I-140 hasn't yet been filed, then the company can stick in an explanation about the acquisition. And there's likely not impact so long as the job is the same and the work location is the same. If the I-140 has already been filed, then, companies want to be on the lookout for the need to file an amended I-140 petition because immigration services require that. So that's actually for PERM-based I-140s. And then for I-140s for EB-1 cases, that's a scenario in which you really, depending on if it's an EB-1C multinational manager case or executive case, that's a scenario where you need to make sure that the entity abroad is still under the same umbrella. If the entity abroad goes away or sold off or closed, and this did happen to one of my clients, they were trying to, as part of this merger and acquisition deal, they were trying to streamline the business, right? And so they decided that certain entities were going to be closed abroad. And so for those, we said, look, even though this person is currently here in the United States as an L1A manager, we won't be able to start an EB1C manager case for them. We'd have to do a PERM. So, it's about transparency and communication ahead of time, because you don't want a situation where, you have to have this difficult conversation with an employee who is an executive as an L1A, and they're expecting that the EB1C is going to be filed, only to find out after, later, that they're not eligible for that, and that the lengthier PERM process has to be undertaken. So that's part of the communication piece, as well as the analysis of the, impact to a foreign national's green card case that's underway. And then finally, if the 485 adjustment is already filed, then it's a situation where if there's an approved I-140 petition already and the I-485 has been pending for 6 months, then the 45 Supplement J, which is an additional form that needs to be filed to notify the USCIS about the portability being triggered. But there might be scenarios in which an employee's case might be impacted if it's before the 6 months mark for the I-485 having been filed. So, those are situations in which, it's a conversation that if it can take place before the deal happens, then maybe there is some wiggle room for, can the deal be delayed, or, can a new I-140 petition be filed in order to save the I-485? So it gets really complicated.
Sounds like a puzzle. And it really is a puzzle, right? Because then you're also, as I'm sitting here listening to you, thinking about weaving in the non-immigrant status as well. Is somebody maxing out? How is that going to impact them if they're a manager on their 6th year and it was, oh, no problem, we're going to get the EB1C. Well, now what's going to happen if you have to switch to PERM? Are there other options? So that's what was going in my mind. I'm like, oh, wow, there's also that other part of the puzzle that HR and Immigration Counsel have to think about and really map out the whole thing.
Exactly.
Because it really is, like you said, it's a puzzle. There's a lot of moving pieces, and it's really important to just be really specific about what's going on and what that individual status is right now. So we had a situation, it's been several years, but because the company reorganization was not going to take place for another year and a half, they were able to, with bringing HR into the process, work on getting that multinational manager cases done for their key executives. So having that, knowledge up in advance might really help in the long run. But those are just some key things to think about.
Great points. And I think, for I-9 perspective, what are some key considerations for HR and global mobility to take away in a mergers and acquisition context?
Yeah, so that's, the main thing is the employer going to hire the individuals as all new employees as a result of this, reorganization or merger acquisition? If yes, then the I-9s need to be completed for all employees, and typically within the 3 business days after that merger acquisition takes place, there's closed. But if there's going to be a successor in interest and the new organization is going to assume all the rights and obligations and liabilities of those I-9 forms, they don't necessarily have to do anything with the employees. No new I-9s. They need to make sure that is a re-verification needed? Is someone coming up on that time? But those are in the normal course of business. The big thing that they also have to factor in when they're doing their checklist for M&A is, are these I-9s in good order? Are we going to have a financial impact? Is there something that needs to be written into the deal whereby the acquiring company can get reimbursed if the I-9s have major flaws in them and the company goes through an audit with ICE and is fined? So those are key things to think about. A lot of it is just the timing and then the financial aspect as well.
Yeah. And the more notice you can provide to companies can provide to Immigration Counsel, the more that we can help, right? To make sure that there is no surprise at the end.
Yeah, absolutely. Absolutely.
Great. I think that's a wrap for today's session on M&A and impact to green card cases.
Yeah, so we finished our 3-part series. And if you don't already follow us on WR Immigration's LinkedIn page, please do follow us, as well as Miki and I with our individual profiles. And we take these episodes that we do every week and we turn them into a newsletter so that you can get the summary about it and you can also subscribe. So we would love to have you subscribe. And thanks again, Miki.
Thanks.
Good to see you.